Just a couple of questions to start off with. Mr. Crane, in looking, and I did read extensively your Syrian Accountability Project, one of the questions that I still have, who else is doing something that might be parallel to what you're doing? Because I know you have many stakeholders and many people who are part of this effort. And I'm wondering, for purposes of prosecution, how legally actionable is the evidence that's currently being collected? You know, as you cite a time and place when people were butchered or mass rape occurred, you know, Dr. White focused extensively on the centrality of the witness. And I remember when we were debating the Yugoslav War Crime Tribunal here, we had, matter of fact, one of the studies, the Shell study, suggested that we were losing in almost like the dew in the early morning as the sun came out. We were actually losing witnesses, forgetfulness. Some were dying. Some were deciding, I've had enough of this, I'm so traumatized. So time is of the essence to benignly capture the witness so that he or she or they can bear witness to the atrocities in a meaningful way. So I'm wondering how much of that information, witness files, are we assembling that potentially could be turned over to prosecutors with all the protections of a witness protection effort underway?
Thank you for the question, Mr. Chairman. First, it's important to note that there are good-hearted people around the world trying to seek justice for the people of Syria, and they're doing it in many important ways. The Syrian Accountability Project is an attempt to take almost terabytes of information that's being gathered by these organizations and be a bridge between that information. Some of it is credible, some of it is not. A lot of it is not. And build a bridge between this information and creating a mechanism, a cornerstone by which a local prosecutor, a regional prosecutor, or an international prosecutor can then build a case-ready case against these individuals who commit war crimes and crimes against humanity. So that is our purpose. It is, to my knowledge, the only effort, but backed by a lot of good people. And I'm honored to be representing all of them, to include students from Syracuse University College of Law who are here today, who are working diligently pro bono also to assist. But again, we're approaching this practically. Again, with Dr. White and myself and many others from around the world, we're looking at these from a practical point of view, not an academic exercise. Can this case be proven? Can we prosecute, regardless of what the form may be? And the answer is yes, it can be done, and it will be done. Justice must happen for the people of Syria. How that characterizes itself goes the panoply from the ICC, a variation of that, all the way down to a local court. Your resolution, I think, is important in that it lists the central item of that resolution, that is justice for the people of Syria. And I applaud this committee and you, Mr. Chairman, for bringing the attention of the American people to this, and that is justice for the people of Syria. But at the end of the day, this case can be tried in an appropriate form so that justice can be done openly and fairly. And the Syrian Accountability Project is just an effort, not the effort, but an effort to assist that prosecutor in that justice mechanism.
Dr. White, did you want to comment?
No, I don't really have anything
okay.
to contribute.
If I could ask you, Dr. White, then in your comments, your testimony, you really went into great length about how important it is for the prosecutors, for the court, to establish a trust relationship with the victims. You also point out, and I know that from at least witnesses that I've met with, as a matter of fact, I chaired a number of hearings. One of our witnesses brought women with her who had been raped in Bosnia, and that was Bianca Jagger. And when I met with the women, the trauma and the emotional just pain and suffering and agony that they conveyed was just, it was numbing. And then they were then being called upon to be part of a prosecution in the case of at least one of those women. Very, very difficult. And I'm wondering over time, particularly as, God willing, healing sets in with someone who has been so traumatized, to relive it. All the more reason why the sooner the better. Delay is denial because, again, important witnesses who may have been hurt themselves or observed it are less likely to come forward. I think the longer this clock plays out. Professor Rapkin said that it is out of the question to launch while Assad is in power. I think when we follow that, and I think Secretary Rademacher's point about the disingenuousness of standing up the Yugoslav court, I remember contemporaneously as well. It was like there was a cynical side to that, but there was also many of us who just wanted it to work and to work robustly and to hold the bad actors to account. But in lieu of doing nothing, that was their default. So the question is, if you could really elaborate a little bit further, and anyone who would like to take it, on the importance of the witness, and again, looking at your suggestions, Mr. Crane, you said the domestic option is the preferred option, but of course that has a built-in delay because there's no peace, sustainable peace, as you point out, in order for all of that to happen. And you talked about the third option, a regional court, with Arabs trying Arabs, Muslims trying Muslims, and Syrians trying Syrians as a preferred option, rather than the Westerners. Of course, there could be a support capacity there, to help stand this thing up, and as well as financial. But if you could talk about that witness even further, because I don't think that sense of urgency is understood in Europe, the United States, that like to do on a morning, these witnesses will go away.
Well, you're absolutely right. And that's why in my written testimony, I strongly encourage this. I know there's a lot of debate as to how this should be set up, whether it's the ICC, should it be a separate standalone, should it be domestic. I would just make the point today that whatever forum is pursued, it must be done immediately, because these witnesses will dry up, not only for fear of being harmed, but some will be killed. And also, if they don't feel that you are there, and this is why it took us months and almost years to be able to extract the trust in the witnesses. And if you're not there, they're not going to come forward, because they have to be fearful that they will lose their life and life of other family members. So the sense of urgency, if you do want to collect the evidence, which I mentioned is principally witness testimony, it needs to be done in a very short order.
I would support that statement. That is one of the reasons why this international effort, the Syrian Accountability Project, is putting in place on the shelf quickly, so that when it's time, when it makes sense, we can move forward quickly. In any criminal situation, you do have to preserve evidence. You may need to make sure that witnesses are protected and that witnesses are alive for the future court. So I think that it's important for this committee to understand that's why we have the Syrian Accountability Project and the Chautauqua Blueprint, copies of which this committee has, which is a statutory framework to create any options that we've been talking about this afternoon, to include the contemplation that perhaps the ICC prosecuting those who bear the greatest responsibility, but the statute itself also contemplates the prosecution of the next 100. So there's a combination there, but I can assure you appropriate expediency is in the back of our mind. We want to have this. It's never been done before quite like this. We usually wait, then we react, then we decide. What we're trying to do here is to have something in place so that when the appropriate political solution is finished, then the international community, the local and regional groups are ready to, in fact, put in place an appropriate justice mechanism.
Well, I think all of us are greatly indebted to the work that you're doing to get this in place, so we don't wait till after the fact. And so thank you, and of course all of you are bringing your extensive experience to bear on trying to find solutions, and this subcommittees deeply appreciate that. One of the things that Professor Rapkin said that I was hoping to ask him about was that the work of the tribunals is not well received. I was in Vukovar a month before it fell with Congressman Frank Wolf. And the Vukovar three were eventually held to account at the tribunal. The atrocities that were committed were horrible. Well, I've, along with Mr. Wolf, have met with a number of people who were victims, and they couldn't have been happier with the outcome that finally somebody was held to account. And the same goes for Mladic and certainly Milosevic, who died. I mean, it seems to me that the snapshot of, well, somebody might be unhappy. Well, the news media that was pro-government and pro-Serbia and pro-Milosevic might not be happy. And the disinformation and the propaganda, you know, it takes a while to wean people away from that. But, you know, it seems to me that well-received ought to be seen in a larger time frame as well. Because when you hold these people to account, future generations as well as the victims do feel a sense of justice has prevailed. And I wonder if any of you have any comment on that, because I was struck by that, and whether or not David Crane and Dr. White, you experienced that yourselves. I mean, I know that you had a tremendous rapport with the people. I remember talking to you contemporaneously. You went out and held town meetings and talked to people to explain the process, very often at grave risk to your own security, but you did it anyway. And so if it's explained, it seems to me that potential hurdle can be overcome as well. Yes.
Mr. Chairman, if I may start this ball rolling, two thoughts here. One, I think there is a need to push these international and internationalized mechanisms to recognize their responsibility in making what happens in the courtroom accessible to the communities most affected by the crimes. And that's a challenge for all of these institutions, all the more so because they render justice in highly divisive, polarized situations, as you were suggesting. And I think it's important to remember, while we often and should cite the Nuremberg precedent, it wasn't as if those trials the following day seemed to bring the German people to confront the crimes committed in their name. This takes a while for these lessons, for this confronting who did what for what reasons to really seep down. And I think we've got to allow a bit of a time frame and not impose on it snap judgments. I think that's very important.
Yes, Mr. Crane.
I've got two examples of why and how justice for people who are victims of horrors that are almost undescribable in any form, victims of atrocity. When I unsealed the indictment against sitting President Charles Taylor in June of 2003, it created a beginning, a political dialogue, as well as a legal process that at the end of this, over a period of 2 years, even though there was a lot of diplomatic and political angst, it laid a foundation by which the Liberian people could elect for the first time, freely and without fear, a president, a female president, the first female president in the history of Africa, and it allowed Liberia to move forward with that new election. The indictment of Charles Taylor created that political, legal, practical condition by which Liberia possibly may have a new future. That is a specific and direct result of an international tribunal seeking justice. So that indictment created that possibility. But for that indictment, it would not have happened. I also want to underscore, and I've said this probably too many times in this hearing, and I do appreciate this time, but let me just give you a small vignette that brings it home. Yes, I did walk the countryside. In fact, Richard Dicker and I and Al White also walked the countryside together, listening to the people of Sierra Leone, tell us what took place. I was in McKinney, the headquarters of the infamous Revolutionary United Front, Bodysanko's group, and Samuel Balkery the Mosquito, because he liked to drink the blood of his victims. And I was giving a town hall meeting in a school for the disabled, many of them disabled by the RUF themselves, blinded, maimed, mutilated. And I was, my custom was, I stood in the middle of the group as opposed to at a high table. I wanted to let them know that I'm listening to them at their level. And a young man stood up. He was deafened by the RUF intentionally, and he was also maimed. He looked me dead in the eye and he said, "I killed people. I'm sorry. I didn't mean it." And he fell into my arms weeping. And as he wept, I looked over and another young woman stood up, about 20 years old, holding her child. She was missing a vast portion of her face, and through cracked lips clearly looked me in the eye as well, her only remaining eye, and said, "Seek justice for us." So this is why we do this. Regardless of comments by individuals, this is why we do it. It's for the victims. It's for the voiceless who cannot speak for themselves. So this is an honorable thing to do, and modern international criminal law is not perfect. It's 2 steps forward, 1 step back. But it needs to be supported in whatever capacity it is, so the voiceless currently in Syria can have some sense that life can go on under the rule of law.
Yes, Dr. White.
I just want to add one quick comment. I think right now we could build on the recent example of Charles Taylor as a former sitting head of state with his conviction in April of 2012 and his recent appeals that was upheld, 11 counts and a 50-year conviction. Right now we have credibility that we can bring people to justice and hold them accountable. And just one quick story that I will not forget, as David pointed out, we were out in the countryside, not only in Sierra Leone, but Liberia. And when Charles Taylor left Liberia on August 11, 2003, he looked the people in the eye and said, "God willing, I'll be back." That sent the shiver down the spine of people not only in Liberia, but Sierra Leone. And they were fearful he was never coming back. And my witnesses repeatedly would call me and say, "Doc, Pape cannot come back." I said, "I promise you, Pape will not be coming back." And when we were at The Hague, during his recent appeals verdict was read, we were in the chambers. I had a number of witnesses call me from Sierra Leone and Liberia. And for the first time in their life, at least in modern time, the last 10 to 15 years, they could breathe a sigh of relief because they said, "Doc, you said he's not coming back. Now I can go to sleep tonight because I know he's not coming back." That's about as powerful as you can get, that you know you can't get everybody, but you need to hold these people accountable, and it needs to happen quickly. We've learned a lot of lessons. This doesn't have to take a long time to get done. However it turns out, it needs to get started, and it needs to get started now. Thank you.
So would that add additional merit to Secretary Rademacher's argument that Article 16 of the Rome Statute makes it less likely that a guy like Charles Taylor could, on the interim basis, go to Nigeria and then be apprehended to The Hague under the Sierra Leone Special Court and then prosecuted? Is the ICC that rigid? I mean, one of the additional points, and maybe Secretary Rademacher, you might want to further elaborate on this, and why I believe that the Russians, and I could be wrong, but why I believe the Russians are less likely to obstruct the creation of such a court is that it holds all sides to account. And we know the al-Qaeda operatives and many of the Syrian rebels are doing horrific things. And, you know, when you're getting tortured, you don't say, "Hey, are you a leftist or a rightist or anybody in between?" You know that it hurts and sadly often leads to your demise. So does that lend credibility to why the ICC might not be the suitable means for this to go forward?
I think the answer to that question is yes. We've talked about a number of historical situations here. I think a key distinction between the situation in Syria today and for example, the one in Sierra Leone, when you gentlemen began your work, was Charles Taylor was no longer in power. In Syria, President Assad is still in power. And that creates a fundamentally different dynamic. And if the desire is to bring him and perpetrators of gross violations of human rights under him to justice, it is a much more challenging situation than if these individuals have already given up power. And I believe that from a purely humanitarian point of view, the #1 priority is to persuade them, well, to bring about a change so that they leave power and are replaced by hopefully more democratic, more tolerant officials. And that to me has to be the primary objective, and we're going to achieve that through the use of diplomatic tools. And so I think the first question is, of the various options that we're looking at, how effective would they be as diplomatic tools? All the options suffer from some of the same problems. Most of them that we've talked about would require Security Council approval, or they would require a change in government so that the domestic judicial system could function, for example. But as we look at those tools and evaluate their potential usefulness diplomatically, I submit that the most useful one diplomatically for bringing about a political transition in Syria is the ad hoc tribunal. The potential use of the International Criminal Court will backfire as a diplomatic tool. It will guarantee, and I mean that literally, it will guarantee that Assad will not leave peacefully, because you can imagine the conversation. Diplomats go to him and say, we think it's time for you to go. Will you please leave? And his first question will be, what will become of me once I leave? You've sicked the International Criminal Court on me. Can you make that go away? And I know what the answer to that question is. The answer to that question will be, we can make it go away for 1 year. The Security Council will adopt a resolution. We guarantee you, the Security Council will adopt a resolution that defers the investigation of your case by the International Criminal Court for 1 year. And you can imagine President Assad's follow-up question will be, well, that's very, very good. What will happen at the end of that year? I'm interested because we're talking about my life and my freedom. And the answer is, well, if we're leaning far forward, the answer will be, well, we guarantee to use our best efforts a year from now to persuade a majority of the members of the Security Council, including all 5 of the permanent members, to extend that deferral by another year. And he will say, can you guarantee that they will extend that deferral for another year? And the answer will be, well, no, we can't guarantee that, but we promise to work really hard to try and achieve that. And then he'll say, and what happens a year later? You're going to work really hard a year later. He would have to be really stupid to buy the notion that he's going to escape International Criminal Court prosecution, that for the rest of his life, once a year, the United Nations Security Council is going to adopt a resolution deferring by yet another year the ICC prosecution of his case. And you can imagine all kinds of problems. At one point, one permanent member can object, and that's it. A veto would restore ICC jurisdiction. So someone in his case will never buy the notion that the ICC can be called off. And that, to me, is a fatal flaw in the design of the Rome Statute and of the International Criminal Court. It makes the International Criminal Court the most useful, the most dangerous tool, the most counterproductive tool we could possibly deploy in the current situation. An ad hoc tribunal could be constructed differently. It's not subject to Article 16 of the Rome Statute. And so it could be designed such that as part of a diplomatic settlement where Assad agrees to give up and retire peacefully, the case is withdrawn, the prosecutor is stood down. I submit that ending the civil war in Syria is more important than sending the people who've committed horrible war crimes up until now to jail, especially when we understand that no international institution, no international mechanism is ever going to hold more than 100 or 200 of these individuals accountable. The vast majority will either escape justice. The vast majority of people who've committed these kinds of offenses in Syria will either escape justice entirely, or if they are held accountable, it will be through the courts of Syria under a different government. Because in the, the Yugoslavia Tribunal has handled fewer than 200 cases, the Rwanda Tribunal fewer than 100. 800,000 people died in Rwanda, and most of them died because they were hacked to death by people wielding machetes. I mean, I can assure you that more than 100 people were wielding machetes to kill 800,000 people in Rwanda. But the Rwanda Tribunal, because of capacity constraints, has only been able to look at fewer than 100 cases. So, well, it's a frustrating situation, but the answer the Europeans are going to give us on this problem is it's got to be the ICC. And I think that is a prescription for prolonging the conflict in Syria, which would be a disastrous. It's a cure that would be far worse than the disease.
I'd like to yield. Oh, okay. I'm sorry.
Because I think Secretary Rademacher put some very important issues on the table that really do need to be addressed. The interface, if you will, between justice and peace. The imperative behind this hearing is trying to bring some redress for those who have suffered horrifically in Syria. I think we make a misstep if reflexively we pit justice and peace against one another. Certainly we want both. We want an end to the killing and bloodshed in Syria. There's no question of that. I think it's how we manage those two objectives and manage them smartly without throwing justice under the bus. And I believe that it can be done. I think a good example of that, two good examples, though one with individuals in power, was the Dayton negotiations, wherein Slobodan Milosevic attended, Radovan Karadzic, Ratko Mladic did not attend because, as you know, they were indictees. That peace negotiation went forward. And the second example to cite is the one that David Crane is most familiar with, the talks on Charles Taylor's departure from power that were taking place in Accra when the prosecutor unsealed his arrest warrant or indictment against Charles Taylor. I think it's possible to manage these two carefully, smartly, not just throw one against the other. So I would take some exception, of course, to what Secretary Rademacher said. Lastly, I would fear for any tribunal that had indicted Bashar al-Assad to withdraw the indictment because a peace settlement had been achieved. Let's go back to the victims in Aleppo or Dara. What will be the response and the confidence in justice if, as a result of a political settlement, a prosecutor says, hey, forget it, here's your get-out-of-jail-free card? I think we can do better than that. Thank you.
Mr. Conley.